I really was eager to do this lecture, in part to sort of make connections with the rest of the university, but also to emphasize the law school's eagerness to reach across the university and have connections with the entire university. I'm going to speak on freedom of religion. There are a few areas of constitutional law, as many of you may know, that have really produced the kind of divisions among the justices of the Supreme Court, lower courts, and academics that the area of freedom of religion has. I'm going to paint with a pretty broad brush, highlighting questions more than providing answers. I've tried in some of my scholarship to provide at least what I think are answers or the best I can come up with at the time. But on the whole, I'm going to just try to show the complexity in the area. Let me start with the language of the religion clauses. The First Amendment begins, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's 16 words. And you would be very surprised to see the amount of litigation you can get out of that short amount of text. In part, I think the volume reflects the fact that this is pretty broad language, and it needs to be applied to a lot of different contexts, certainly something that the drafters of the First Amendment were well aware. I think the other thing it reflects, though, is how much strong feelings are implicated when such a deeply personal matter as religious belief, including not having any particular religion, some individuals, the extent to which those emotions are so strong that litigation is apt to result. Let's start with the first word of the text, Congress. Actually, you find in the First Amendment, even though it says the word Congress, that the First Amendment has been interpreted as encompassing essentially all governmental activity, not only governmental activity of the federal branches, but also state and local government. The Supreme Court, though, didn't really make this clear until the 1940s. You have a couple of landmark cases in the 1940s, one regarding the Free Exercise Clause and the other the Establishment Clause, relying on the 14th Amendment of the Constitution, one of the post-Civil War amendments, and essentially saying that made the federal scheme applicable to state and local government. Many of you, even some of the law students, if you're a first year in particular, might be surprised to recognize that the constitutional structure at the outset, essentially you had very little applicable to state and local government. Almost the only relevant constitutional limitations pertain to federal government. The Bill of Rights only applied to the federal government, and the application of the Bill of Rights, of which the First Amendment is part, really has been a 20th century development interpreting the post-Civil War amendments. In any event, you get these cases in the 1940s and that interpret the religion clauses as applicable to state and local government, and that really begins the flow of what sort of is the modern case law of the religion clauses. There really is not much to speak of until you get into the 1940s. Some people have questioned, particularly as to the Establishment Clause, the logic of saying it applies to state and local government, saying that the First Amendment was really all about protecting the people from a federal establishment, and that's all it was about. But it has been interpreted more broadly, and I think if you look at the purposes behind the First Amendment, at least to me, that's a pretty clearly correct interpretation. The law that is encompassed also means more than just statutes. It means government action in any form. So Congress shall make no law respecting an establishment encompasses things not only like regulations in a prison, but things like a city putting up a nativity scene on the lawn of the city hall. That is a, quote, law for purposes of the First Amendment. If you look at the history prior to the adoption of the First Amendment, you have examples in 17th and 18th century Europe which provided the backdrop for our system in the American colonies and in the early United States, you have examples of religious establishments. It's not hard to know when you have an establishment of religion, but the First Amendment doesn't say Congress shall make no law establishing a religion. It says Congress shall make no law respecting an establishment of religion. And that phrase, respecting an establishment of religion, is really what creates and becomes the basis for all the litigation that has ensued. What counts as respecting? Obviously, you don't have to get all the way to an establishment for something to be a constitutional problem. And over the years, the Supreme Court essentially has interpreted respecting an establishment of religion to encompass laws that may lead to an establishment of religion, that may take us down the path to establishment. So what might do that? What are the kinds of laws that would be challenged? Well, sort of the hallmark of an established religion, just to give you, the end point that we don't want to approach according to the First Amendment, the established religion has features, government support of religion, very visible and explicit, and both financial and non-financial. So financially, you could have compelled contributions, people being compelled to contribute to the state religion. That would be a feature of an established religion. You would have government sponsorship of religion, government announcing this is our official religion, and you would have compelled participation in religion. So not only would you be compelled to contribute monetarily toward a religion, but you would be compelled to attend the religious services of that religion, and if you didn't, criminal penalties would be applicable. Well, what kind of laws today are the counterpart? Well, since the 1940s, the kinds of laws we've been looking at, the kinds that end up in litigation in courts, really fall into three basic categories. One is aid to parochial schools, and that aid could take a variety of different forms. The famous 1947 case involved reimbursing parents for the bus fares of their children going to the parochial school. Subsequent cases dealing with things like the state subsidizing the salary of parochial school teachers who teach secular subjects. Much more recently, a U.S. Supreme Court case dealing with the state paying for a sign language interpreter to accompany a hearing impaired child to classes in parochial school. And then in the early 2000s, a case dealing with vouchers that essentially would cover parochial school tuition. The second category is, again, school-related, but now public schools. State accommodating religion in the public schools, here ranging from prayer as part of opening exercises for the day, to allowing for moments of silence, organized moments of silence in the schoolroom, including creation science or more recently, intelligent design as part of the science curriculum, teaching sex education, particular form called abstinence only, that appears to be predicated on particular religious views, requiring schools to permit after-school prayer clubs if they have other kinds of clubs, and having religious invocations at graduation ceremonies. All of those have given rise to litigation, and actually all but the sex education have gone up to the U.S. Supreme Court. The final category is state support for religion outside of the schools, and this is going to be more of a catch-all. Here, typically non-coercive and symbolic, putting up a nativity scene at holiday time in the public square, putting the Ten Commandments on a courthouse wall, putting In God We Trust on our coins, declaring Thanksgiving a national holiday, restricting who can marry whom. And here I'm thinking of the example of the debate over same-sex marriage. The restriction of a sort that certainly is one that some people would perceive as giving the force of law to particular religious views. Having state-paid chaplains starting a legislative session with prayer. These are all things that have been challenged in one or another form as respecting an establishment of religion. When you try to take apart the Establishment Clause challenge, a big part of the issue really seems to turn on a couple of questions. One very basic question that really affects all the financing issues, anything involving state funding of religion, is a very basic principle. And you can find support for it in the history of the Establishment Clause, and that is it wrong to make someone pay to support someone else's religion? You find discussions early on that people shall not be required to pay 1 pence for someone else's religion, or even to be required to support their own, that this ought to be a matter of everyone's free will and decision. Well, if you think about using tax-raised money, that is what you're doing. You are essentially requiring people to pay taxes to the federal government and turning over the money if you are giving it to any type of religious cause. If you're reimbursing bus fares, no matter how you cut it, you are using tax-raised money and you are assisting children to get to parochial schools. Should that be enough to be a violation? Do we want to draw a line between subsidizing bus fares and subsidizing a parochial school's purchase of prayer books? Is there any principal difference between the two? You look at the purchase of prayer books and you say, I can't believe the state should be subsidizing that, but is the difference really superficial? If they're subsidizing bus fares and bus fare is a basic cost of getting to the parochial school, aren't you still subsidizing religion? If you go that far, can you draw a line between prohibiting, say, subsidizing bus fares and prohibiting the state from providing police and fire protection to parochial schools? Everyone would look at that example and say, I can't believe the Establishment Clause goes that far that it actually would say you can't provide police and fire protection, even though that, to some extent, is using state money and applying it to aid religion in some sense. So at what point does aid to religion or a prohibition on aid really become hostility to religion if you deny it? The vouchers became a major case in 2002, and in that instance, vouchers essentially being a means by which parents are given a choice. Do you want the state essentially will give you a certain amount of money? I think the amount of money that was made available was about $4,500 that could be applied to tuition at a private religious school. Is that a problem? Or do you look at it and say, well, all you're really doing is making religious school as accessible to children as public school? After all, they don't have to pay to go to public school. Is it enough to really essentially have even-handedness? You're certainly not making it easier to go to parochial school than public school. And the Supreme Court upheld vouchers. And they said, essentially, the state is being neutral. They're not weighting the choice toward parochial school. They're simply enabling parents to send kids to parochial school as easily as they would to public school. And the Supreme Court thought it was important that the aid was not going directly to the parochial school, but was only getting there indirectly by going to the parents. One difficulty with the voucher decision is that principle that I suggested, at least many people would say underlies the First Amendment, that someone should not be compelled to support someone else's religion. If you're providing tax-raised money for parochial school education, whether that money is going there directly or indirectly, if it's influencing the parent's choice, neutrality may not be enough You may have to say, as some of the Supreme Court justices did, this was a 5-4 decision, that really this is not hostility to religion to withhold this type of state aid. Rather, it's simply vindicating this very basic principle that you don't compel people through their money they've been compelled to pay through taxes to, in effect, subsidize religious education. In the religion in public school cases and the cases involving symbolic support of religion, a major issue really is to what extent is government sponsorship or endorsement of religion a constitutional problem? Is it enough to say the government is doing something, they're not coercing anybody to do anything, but what they're doing is they're putting a nativity scene on the lawn of the city hall, or they're creating a prayer opportunity, say at a graduation ceremony. They're having an invocation or a benediction, but they're not saying everybody has to stand there and recite it. They're not saying you have to even bow your head, but they're doing it. They are indicating, sending a message by what they're doing, sending a pretty clear message that the government endorses a particular religion, or at a minimum endorsing what you might say is religion over non-religion. And that often takes the form, say in these graduation contexts, of delivering what's often called a non-denominational prayer. So it's a prayer that's kind of like, you can tell it's a prayer, but exactly whose religion is being endorsed. It's religion over non-religion, but it's pretty hard to tell much more than that. Why would you worry about sponsorship of religion? What's the big deal? If you're not coercing people, why is it a problem for the government to essentially do things that communicate government support of either a particular religion or of religion over non-religion? And at least some of the reasons that can be given are the extent to which government sponsorship of a religion or of religion over non-religion has an alienating effect on non-adherence to the sponsored message. So if you are not a member of the religion that's being sponsored, are you being alienated from your own government, from basically the civil union? To what extent are you, in a sense, even though you're not being pressured in any large sense to comply, aren't you subtly being pressured to conform? And if you're living in a society with all types of endorsements cumulatively, do they have a coercive effect on people's really free choice in religious matters? So what you start to see is this tension between the establishment and the free exercise clause, and between government support of religion. To what extent does government sponsorship, even if it looks kind of benign, to what extent are we encroaching on people's really free will in choosing religion? Is government pushing them in one direction? Another problem with sponsorship in and of itself is the one raised by some of these non-denominational prayers, also raised by, if you've ever seen some nativity scenes, for example, a famous case in the 1980s in the Supreme Court involving Pawtucket, Rhode Island, a nativity scene, which next to the nativity scene, you have Santa on his sleigh, and you have cutout figures of clowns and bears. And you might say, if you're really religious, you would say, this is sacrilegious. What does the state think they're doing, putting a nativity scene, which is certainly a holy aspect of the religion, what are they doing putting it in the middle of clowns and bears? By the same token, these instances of non-denominational prayers are so, framed in such generality and in such a really sort of cookie-cutter fashion that they really do have an offensive quality for religious people. And in a sense, then, the problem that raises is government sponsorship of religion, in many people's view, is bad for religion, bad for the sponsored religion. That when government gets into the business of religion, it can trivialize it. And you have a whole strain of thought, really, the Roger Williams, going back to Roger Williams, that really emphasizes that aspect of the Establishment Clause as a concern, that government involvement in religion tends to degrade religion. Well, you've got this one point of view that would argue then government endorsement of religion in and of itself is a problem. You have a debate, though, very clearly framed in the modern Supreme Court that says endorsement isn't enough. Showing the government is endorsing religion doesn't show an establishment violation. That's not something we should regard as taking us on the path to establishment. What you really need is coercion. You really need to be able to show not that the government is supporting a religion, but that they are really coercing people to abide by it. So, for example, if you go back to the school prayer decisions, which really were decided on the ground of endorsement, if you thought about them in terms of coercion, the question would be, if you have a child in school and there are prayer exercises in the front of the room, and, as most statutes did, the child can leave the room if he or she wishes, or if his or her parents say they can. They're not being compelled to participate in a strict sense, but is there still coercion? Is the peer pressure enough that we're going to call that coercion? Some of the justices would say that's not really coercion. Coercion would really be if we told the student, you're going to be marked absent if you're not there participating in the prayer. But other justices would take the notion of coercion maybe and apply it a little more broadly. So it's not that you eliminate the grayness completely. Even if you go to a coercion test, you're going to have cases where people are going to differ, do we have coercion or not? But still, there's no question, if you move to a coercion test, the constitutional standard, the limitation on the state is clearly much less. Things like a nativity scene on the courthouse lawn, there's no way you're getting coercion out of that, whereas if the question is establishment, I think it's pretty clear. Well, what I'm giving you is sort of a different sense of what you might call a strong view of establishment, one which I would say would treat endorsement of religion clearly as a problem, which would say government financing of religion is a problem, even if it's equalizing. So the voucher is a problem. It's not enough to say, well, we're just being equal. We're saying that's a separate principle. You're not supposed to coerce people to support other people's religion. That's what I would call a strong view of the Establishment Clause. Is that really, though, an anti-religious position to take? Is it hostile to religion to oppose vouchers for parochial schools on the principle that people shouldn't be compelled to support other people's religion? Is it anti-religious to oppose prayer exercises at the start of a school day? Similarly, is it anti-religious to say, I don't think that nativity scene should be on the grounds of City Hall? My answer to that is no. I personally take what would certainly be considered as a strong view of the Establishment Clause, and I'm certainly someone who believes deeply in the importance of religion for myself and for others. And I would argue that a strong view of the Establishment Clause really honors religion rather than being anti-religious. I think the framers of the Establishment Clause, and there's certainly historical support for this, saw that government support for religion, financial or non-financial, is bad for government and bad for religion, and that directly or indirectly it interferes with people's religious liberty. Again, raising tax raise funds to support another person's religion, I think does go to the heart of religious liberty. But more broadly, if you think about what the weak interpretation of the Establishment Clause does, an interpretation that says that is much more permissive toward government support of religion, what's the effect of that? Well, elected officials in a democratic society are not going to favor all religions. They are going to favor what we might call majoritarian religious views, mainstream views. So some religions lose out, minority religions in particular, and certainly favoring religion over non-religion by the same token. Views of people, and again, keep in mind, these are strongly held views. Saying to someone you need to support a religion when they deeply do not believe in religion is a major interference with their religious liberty. So again, going back, there's a lot of justifications for a strong view, but I think even going back to Roger Williams, you find strong support even among people, and you find many clergy who would take a very strong separationist view on the view that this is really ultimately the best thing for religion. Let me talk briefly about the second clause, and that's the free exercise clause. A government can't prohibit the free exercise of religion. I think reading that alone is enough to tell you there's a problem reading the Establishment Clause as requiring coercion, because in effect, free exercise says you can't prohibit the free exercise of religion. That directly addresses the question of coercing people with regard to their religion. If coercion is covered by free exercise, why would you even have an Establishment Clause if all you expected it to do was guard against coercion? It would simply be duplication. Presumably, the framers meant a little more by the two clauses, and they wouldn't have included an Establishment Clause. You have almost a principle of interpretation of the Constitution, sort of like the Bible, to use an apt example for today, that you don't just assume words are used like they were clearing their throat. The idea is if the words were there, they were intended to have some independent significance, and I think the Establishment Clause loses its significance if you interpret it to just guard against coercion. Free exercise clearly does that. So what kind of problems do you have under free exercise? A very small proportion are laws that explicitly or even implicitly prohibit a group from practicing its religion. A law that really targets a religion and disadvantages it. You have a modern example. Actually, in the 1990s, the Supreme Court had a case involving essentially the Santeria religion that has as one of its beliefs animal sacrifice, and there were a set of Florida laws in a locality that essentially were drafted for the purpose of prohibiting adherents of the Santeria religion from practicing their religion. There were all kinds of ways in which people were basically able to kill animals left and right, but they managed to draft a law that was very obviously tailored to animal sacrifice for religious purposes. And the Supreme Court struck it down. They said this is a thinly veiled effort to basically prohibit people from practicing their religion. The typical free exercise problem is one in which you don't have the government explicitly aiming at a particular religion, but instead passing laws of general applicability that impact certain people in a particularly disadvantageous way because of their religion. So these are instances in which probably the legislature, it never even occurred to them that they were disadvantaging some people. particularly because the disadvantaged people will be adherents of minority religions, including some religions, say Native American religions, that the legislators might not have the vaguest idea about. But you have laws like a law requiring a flag salute, which clearly disadvantages Jehovah's Witnesses differently than other people. A law requiring compulsory schooling past 8th grade, which affects, say, Amish children very differently on the view that their religion really depends upon not having formalized schooling and the type of acculturation that occurs past the 8th grade. Requiring in the military, nobody can wear anything on their head when they're indoors, disadvantaging Jewish members of the military, Orthodox Jews in the military, who feel the need to wear a skull cap at all times. Someone required to have their picture on their driver's license. You have a case that went all the way to the Supreme Court, challenged by a fundamentalist Christian who literally took the commandment about no graven images and believed they could not have their picture on anything. It would be a violation of the commandment about no graven images. So again, you have this dilemma: to what extent are we going to protect the minority from, in this instance, majoritarian rules that really on their face, are not even thinking about religion? Now, maybe they're insensitive to religion. Maybe, if it was their religion, they would realize they were disadvantaging it by a broadly applicable law, but it may simply never have occurred to them. It may be ignorance. Whatever it is, what do we do to help people when there is a general law that really disadvantages them? The answer up until 1990 was we let courts carve out an exemption for people whose religious free exercise is burdened by state laws of general applicability, unless the state can really prove, and it's a difficult proof, that it's essential that these people abide by the law, even though requiring them to abide by it is really interfering very severely with their religious liberty. This decision in 1990, an employment division against Smith, was decided by a 5-4 decision. Remarkably, it was there was such strong sentiment against the decision in Smith by religious groups, by civil liberties groups, across the political spectrum, that within a couple of years, Congress passed something called the Religious Freedom Restoration Act that essentially, and it was virtually a unanimous Congress that did it, both in the House and Senate, in a sense, tried to overrule the U.S. Supreme Court's interpretation of free exercise as not allowing these type of exemptions, and the federal law said courts should go back into the business of carving out exemptions for individuals who are adversely affected by these broadly applicable laws. Several years later, the U.S. Supreme Court struck down the law. They said that law exceeded the power of Congress, so Smith remains basically the law of the United States, and the ultimate effect, there are some small exceptions that the opinion allowed for, but the ultimate effect really is to disadvantage minority religious views. Again, if you think about the Bill of Rights, the essence of the Bill of Rights, whether you're looking at free speech or freedom of religion, is to worry about minorities being oppressed by the majority. You don't have a free speech clause because you're worried about Congress or states suppressing popular opinion. You're worried about them suppressing unpopular minority opinion, and I think we have that same problem here in the religion area. The interpretation of free exercise, though, really puts minority religious views at a distinct disadvantage. An important development in this area has been the growth of state constitutional law. States have their own constitutions, and they are the ultimate authority on the meaning of their constitution. So the Georgia Supreme Court's interpretation of the Georgia Constitution cannot be overturned by the U.S. Supreme Court. As a result of that, you find, in this instance in particular, many states interpreting their free exercise provision, and virtually every state constitution has a free exercise provision, may not be worded exactly like the U.S. constitutions, but they have something pertaining to free exercise, and many have interpreted theirs to provide the kind of protection that the federal free exercise clause used to provide. When I was at Cornell for 5 years, I taught a religious liberty clinic in which we took actual cases. And one of the cases that we litigated involved a prison guard who was a Native American who followed the Longhouse religion, the traditional Native American Iroquois religion. And he was ordered, consistent with the prison regulation, that said male guards' hair length could not be more than 1/4 of an inch below their shirt collar. He was ordered to cut his hair. He responded that cutting his hair in the back violated a basic religious precept. And this was a religious view shared by the Longhouse, that essentially you were supposed to grow your hair long in the back. That brought you closer to the earth and closer to the Creator. And whether or not you share that view, I don't think it makes any less sense than many religious views, right? It may not be ours, but it can really deeply make sense to people. And he would not cut his hair. He was fired from the prison. And ultimately, his case found its way to the clinic that I was running. We brought suit for him to be reinstated with back pay. And at the time, we ran head-on into employment division against Smith. It was pretty clear federal law was not going to help us. So this was in upstate New York. We argued New York has a constitutional provision protecting free exercise of religion. They were free to interpret it as they chose. And we essentially wrote a brief that was a critique of the U.S. Supreme Court's interpretation of the federal provision. And we said, just because the Supreme Court of the United States is wrong, the New York courts don't have to be wrong. They can interpret their own provision. And we won on that ground. And it was upheld on appeal and became a significant precedent for other states. And you've really seen a lot in the area of state constitutional law in this realm. Very briefly, where is free exercise and establishment going in the Supreme Court? As I said at the start, this has been a very controversial, an area of great division in the courts, particularly the Supreme Court, for 50 or 60 years. And it very much continues that way today. If you look at the lineup on the Supreme Court, you see them very closely divided on strong versus weak interpretation of establishment, what I would call strong or weak interpretation of free exercise. And we've had enough changes in the last 5 years. The Chief Justice, Rehnquist, leaving for Chief Justice Roberts, Justice O'Connor leaving for Justice Alito, Souter leaving for Sotomayor, and most recently Stevens for Justice Kagan. Exactly where we are is really hard to say. An interesting element is Justice O'Connor's leaving, even though she was typically characterized as a, quote, conservative on the court. Her replacement by Justice Alito definitely shifted the balance, at least as between those two. Justice O'Connor was very clearly a proponent of a strong reading of establishment and a strong reading of free exercise, one that would allow for exemptions. It's certainly clear Alito doesn't take a strong view of establishment. Unclear where he comes out on free exercise. But altogether, I think you really see it's very hard to ascertain just where does the court stand today. Again, this has been an area of tremendous turmoil. I think it will remain that for many years to come. I think that's really ensured not just by the breadth of the language of the religion clauses, but how deeply people feel about matters of religion. Thank you. I think there's time for a few questions.
Currently, there's a up-and-coming case in North Carolina where a girl had a nose ring at her high school, and they told her to remove it, and she didn't. They suspended her. She claimed that it was her religious belief that she had to have her nose ring, and she claims her religion is a spiritual body piercing-based religion with her and her friends, and they claim they have a sort of initiation ritual, a set of beliefs. I was just wondering, how have the courts defined a religion, and how will they do it?
I mean, that's a terrific question, because one of the issues, and it occurs in that context typically, free exercise. I have a right to do something in keeping with my religion. You don't tend to have definitional problems with establishment because typically the government isn't being so supportive of anything other than what you would consider a mainstream religion. But in prison cases, it's not at all uncommon to see these kind of definition problems raised. The short answer really is, if you look at the Supreme Court precedent, they have never clearly defined what counts as religion. So you have decisions being made. You have old cases. I shouldn't say they've never defined it. You have old cases saying things like a religion is something that defines your relationship to God. Subsequently, the court certainly takes a broader view. It moves away from that narrow definition of religion. But exactly where they end up is very difficult to say. There have been a number of approaches that have been suggested by commentators. Some people, one of the probably best known approaches is sort of an analogical approach, which says if you're trying to argue something is a religion and it's sort of in a gray area, what we try to think about is in what characteristics does it share with things that are obviously religion, okay? The example that you give, often you find some courts, rather than reach the question, or at least they merge the question of what is religion with the separate question that's, I think everyone would agree, a proper one, is someone claiming a sincere religious belief? If they can say, and you have some prison cases, you know, where people are saying, my religion is to have a sword in my cell, and they go, I don't think so. You know, this is not a sincere religious belief. We're not going to reach difficult questions of defining religion. I suspect this case a lot might turn on, is this really sincere? But if they get over the sincerity hurdle, they really do have to get into that definitional area. And the Supreme Court has been anything but clear. And again, they had this old decision, which they've clearly moved away from. There's actually a decision in the early 50s where Justice Douglas wrote an opinion and has a footnote, and he says something like, well, by religion, we're not excluding, and he starts saying some things like secular humanism that some people were scratching their heads and saying, I don't think that is religion. So you've got, that's kind of what they call dictum in the opinion, stuff that was really just kind of by the way language, not necessary to the holding. But that's a great question.
I want to be sensitive to our students. If you have further questions, why don't you come down front and we can continue it, but some I know need to go to class.
Sure.